So now it's March the 1st, 2010, and we don't know what to do. Nobody's talking to us. We have the only information we've received is from the media. But fortunately in Michigan and under federal law, we have what we call the Freedom of Information Act. And that provides that public bodies have to provide the citizens with information. Now, that's not completely, that doesn't mean all information. The statute does say there's certain information that is not available to the public, and they call that exemptions. But the Freedom of Information Act has some interesting legal consequences. In a normal lawsuit, you're injured in an automobile accident, it's your obligation to bear the burden of proof that the driver was negligent that hit you, and it's also your burden to present your case first. We call that the burden of going forward. The Freedom of Information Act provides directly to the contrary, and I think some of the public bodies don't understand that, and I think in this particular case, perhaps the court didn't either. But the public body has to tell you what documents they have and whether they're exempt or non-exempt. And then it's up, if you don't agree with their exemptions, you have a right to file what we call a Freedom of Information Act lawsuit. And you don't have to prove anything. It's the obligation of the public body, in this case the Michigan State Police or the Oakland County Prosecutor, to say these are exempt, here's why, and they have to go to the court and tell the court that to begin with, and they have the burden of proof. So it's a statute very much in favor of public exposure. It also has some provisions about payment of fees, and I had what I consider a kind of acute problem with that in my case against the Michigan State Police that we'll discuss later. So those are some of the guiding rules of Freedom of Information Act requests. Once Dave Binkley found out that I was going to start this case against the Michigan State Police, he volunteered to be the attorney. And without my knowledge, he wrote to my kids and said that he would like to represent the family in that lawsuit. And that's the reason Dave became my attorney in that case. He and I are members of the same firm, and that has some interesting problems because you're not entitled to have your attorney fees paid if you represent yourself or if the person representing you is from your law firm. But Dave, as you will find out later on in this presentation, had been convinced that Bush was involved and that we had a good case, and he agreed to proceed. So we filed a lawsuit on April 27, 2010, after the Michigan State Police denied my request to get the information from the Michigan State Police on the Bush file. We didn't ask for any other suspects' files. And we got the usual response that they didn't have to give us anything. There was some attorney skirmishing initially about it, and but I don't want to bore you with all of that because they ultimately gave us the information we needed. Also, when they asked me to send the check up, they told me it would be $11,000 and change to get this information. I sent up a check for $5,500 and change and said paid under protest because I didn't want it to be controlling. The young attorney general on the case sent it back to me and said it has to be unconditional. We went before Judge O'Brien, and she said, Barry, pay the money. I put pursuant to court order on the check, and this young attorney general sent it back to me saying it has to be unconditional. Judge O'Brien saw through that and said cash the check, and I'll figure it all out later. And Dave Binkley got a call in early December saying, if you pay the balance due, the other $5,500 and change, I will give you the documents. And I was interested in the documents. I could run through the money problem later. So I paid them the extra money, and on December the 15th, 2010, the Michigan State Police delivered to Dave 3,411 pages on the Bush involvement in these killings. I would first of all like to take this opportunity to compliment Detectives Gray and Williams on the superb job they did in tracing down the possible Bush involvement. And nothing that I say in the remainder of this presentation should be deemed as being critical of what they did. They thought of things that I never would have thought of on my own. But there were a couple of documents that I wanted further explanation on, and the Freedom of Information Act, which we call FOIA. If I use the word FOIA later on in these presentations, that's what it means. We're missing. You're going to find out that Bush passed a polygraph test in January 1977, which authorized his release from the Flint criminal charges. And the files indicate that the initial tip on Bush was tip number 369, and it has cleared by in the lower corner. They checked the polygraph box. The files also indicated that they received a couple of more tips on Bush as being involved in these killings, and they have scratched on them cleared by tip 369. The Michigan State Police reports also indicated that Detectives Gray and Williams had that polygraph test looked at by 3 experienced polygraphers. And we were told orally that the results were that he did not pass that polygraph test. They also indicate that Cabot, the polygrapher up in Flint who did the original one, was a young polygrapher and had a very short period of time in that position with the Michigan State Police. But the results of these 3 polygraphers were redacted from the Michigan State Police reports. And we're going to get into the polygraph inconsistencies a little later on in this presentation, but we wanted that unredacted copies of those polygraphs. The day of the hearing, when the case was closed in May of 2011, the Attorney General presented to Judge O'Brien and to us an order from the 48th District Court. And it said, nobody has access to the search warrant or search warrant affidavit on the Bush residence that we talked about, dated October the 28th, 2008. We didn't know anything about that. The search warrant and search warrant affidavit were not in the 3,411 pages that we got from the state police, and they were not listed as an exempt document. So we didn't have the slightest idea why that order was being presented to Judge O'Brien. And when I got home, I looked at the search warrant, or the order, and it didn't even have a case number on it. I've been practicing law for over 50 years, and I've never seen a court order without a case number. And we're going to get into the search warrant problem later on again in this presentation, but I told the Judge O'Brien that we wanted the search warrant and the search warrant affidavit, and then there was a third thing we objected to, and that was that there were references to the PowerPoint presentation that Detectives Gray and Williams had started in early 2009 that we referred to earlier in this presentation. And there were notes in the files that PowerPoint was turned over to the Oakland County Prosecutor, Michigan State Police said they did not have a copy of that search warrant or search warrant affidavit. I asked for permission to talk to them about it, but Judge O'Brien allowed them to file an affidavit saying they didn't have it. And obviously you can't produce something you don't have. And so I had no explanation from the state police about what happened to the PowerPoint presentation. And that's going to come up 2 or 3 times further in this presentation. So there were 3 items I was missing or wanted a further explanation on. 1, I wanted the results of the 3 polygraphs contradicting the initial polygraph of Bush. 2, I wanted the search warrant and the search warrant affidavit. And 3, I wanted the PowerPoint presentation. And interestingly enough, in none of my Freedom of Information Act cases have I've been allowed discovery. So I had not been able to ask the Michigan State Police, either by interrogatories or at depositions, where this information was and why they thought it was exempt. But in general, the 3,411 pages I was given supported everything that we had been told or suspicioned happened about the Bush involvement. It included references to the fact that 4 prosecutors, Richard Thompson, the assistant prosecutor under Patterson, David Gorsica, the predecessor of Miss Cooper, Prosecutor Worthy in Wayne County, and Prosecutor Moran in Wayne County, all thought there was possible Bush involvement. There was a memo from Detectives Gray and Williams to Lieutenant Hill of the Michigan State Police, who was Gray's superior, saying, here's the report on Christopher Bush. We believe there's enough circumstantial evidence that if he were alive, we would be charging him with murder. And we'll get into all of this material later on. And then when Prosecutor Cooper told me that Bush and Gunnels were not involved, I filed a Freedom of Information Act letter against her. She wrote back and said, you're not entitled to anything. And I started a lawsuit on May the 14th, 2010 against her for her files on Bush. And that case was assigned to Judge Wendy Potts. So the Michigan State Police case was with Judge O'Brien. The prosecutor case is with Judge Potts. My firm does work for Oakland County, and we concluded there was a potential conflict of interest if my firm represented me in that case, and I retained attorney Lisa Milton to prosecute that case on my behalf. Ms. Milton introduced you all at the beginning of this case about the status of the case and will be appearing from time to time. She was a classmate of Kathy's in high school and one of her dear friends, and she was there at the very beginning. Well, the first thing that happened after we filed the case against the prosecutor is the prosecutor, Cooper, filed a motion to consolidate the 2 cases. She wanted them both before the same judge, and I didn't understand why, because the Michigan State Police have their file, the Oakland County Prosecutor has her file. I wouldn't want to pay for somebody from the prosecutor's office to attend all the hearings with the Michigan State Police, and if I was the Michigan State Police, I wouldn't want to be paying for any questions about what was in the prosecutor's file. And those things I anticipated would include discovery. We opposed the motion to consolidate and said they have separate files. We don't know if there's anything in common. And they both made independent decisions on this, and they might have looked at different materials. And those motions are heard by the first judge. So if you have 3 passengers in a car and they all sue the same driver, they can be consolidated, but the judge who hears it is the first judge to whom the case is assigned. Judge O'Brien read the briefs, heard the oral argument, and said, motion denied. There's not enough similarity between the 2 files at this time to deem that consolidation was necessary. And Prosecutor Cooper then appealed that decision to the Court of Appeals. And Prosecutor Cooper is a former judge of the Southfield District Court, the Oakland County Circuit Court, and the Michigan Court of Appeals. So I have some trepidation that she's filed this appeal to a bench that she's already sat on, but apparently it didn't prejudice my rights, because after several months the Court of Appeals said Judge O'Brien was correct, go back and try the cases separately. Prosecutor Cooper wasn't happy with that. She took an appeal to the Michigan Supreme Court on what we attorneys all know as a discretionary ruling, and taking interim appeals on discretionary rulings are seldom successful. And the Michigan Michigan Supreme Court again said Judge O'Brien was correct. Well, while these appeals were going through, Judge Potts put a stay on any proceedings in her court, and that makes some sense. If the ultimate decision is going to be made by Judge O'Brien in a consolidated case, orders by Judge Potts would not be enforceable, and we'd have to do it all over again. But in December, the case came down from the Michigan Supreme Court, and Judge Potts allowed us to activate the case. The Oakland County Prosecutor then filed something with Judge Potts. I don't know what it was. To this day, I don't know what it was. But she gave Judge Potts something, and approaching the judge separately without letting the other side know is forbidden by my court rules. When we found out she had filed something, we brought this to the attention of Judge Potts, and Judge Potts said, well, right now I'm not going to tell the prosecutor to give you that information, but they do have to at least tell you they filed something with me. And the prosecutor files an affidavit of service or proof of service saying that they had filed something with the court, but they weren't going to tell us what it was. How do you proceed? Well, you take somebody's deposition. So we notice up Prosecutor Cooper's deposition, and she opposes the deposition. She's reluctant to raise her right hand. She's reluctant to obey her constitutional obligation to confer with victims. And after some briefs and discussions, Judge Potts said, the case is dismissed because you're not entitled to anything. Now, there's a way to suppress information, and it's provided in the court rules. You can file a motion to suppress the case, and if the judge determines it correctly, she has to tell the court administrator's office up in Lansing, and it requires a hearing, but Prosecutor Cooper didn't follow that rule. She just filed something with the court. And Judge Potts looked at whatever she filed and dismissed the case. We get nothing. We file an appeal on that. That appeal was argued on February 13th this year, 2013. And at the beginning of the argument, Lisa Milton said to the court, have you had a chance to look at whatever they filed with Judge Potts? And they said no. I couldn't believe that. I think it might have been a misinterpretation of the question or the answer. But how does the Michigan Court of Appeals rule on something that they haven't even seen? Anyways, we finished that argument, and we are waiting for the ruling from the Michigan Court of Appeals as to whether we are entitled to any access to the prosecutor's files on Christopher Bush. While that case was pending and up in the Court of Appeals, there were certain documents that I wanted access to, specifically. And I filed a separate FOIA, or Freedom of Information request, to obtain the search warrant documents. And you'll recall that they didn't come to our attention until after we had filed the first case. in the Michigan State Police case. That didn't come up until after we filed the first case. And while this case was pending, in July of 2011, Prosecutor Cooper accused me of a felony and telling the Channel 4 about the existence of the grand jury and conveying that information as a criminal charge. And I asked for whatever basis she had for this false accusation because it was absolutely false, and we're going to discuss that at length later in this presentation. And from my reading of the Michigan State Police reports, I thought that the state police had given the prosecutor their PowerPoint presentation, and I asked for that. Again, Judge Potts denied me access to this or any other information, and I have taken appeal to the Michigan Court of Appeals on that problem. That ruling came down in January of this year. Basically, I want the search warrant affidavit and search warrant. I want to know why she accused me of a felony, and we're going to really discuss that later. And I wanted access to the PowerPoint presentation prepared by the Michigan State Police. And as I told you, in those two FOIA cases, that's how much documentation we received from Prosecutor Cooper. Zip, zero, none. Then I sent another FOIA letter last year, and we'll get into that at some detail later, but there were several other FOIA requests from the media about the Bush involvement in these cases, and she released the information to the media and refused to make it available to me. However, I didn't have to start a lawsuit here because she attached that information that she'd given the media and some other information and responded to me, and we're going to get into that later in this presentation too. So we've had 3 FOIA actions. We've got one from the state police. We get 3,411 pages, heavily redacted, but decipherable for the most part by us, and the 3 or 4 missing items are on appeal. We have the 2 actions against the Oakland County Prosecutor with at least consistent results. She's offered me nothing, and we're awaiting a ruling from the Court of Appeals on whether those decisions were correct. So that's the summary of my Freedom of Information Act requests, all instituted after March the 1st, 2010, when Prosecutor Cooper told me that there was no Bush or Gunnels involvement. And that opened up a story which is going to take much longer than what we've taken to date to respond to.